is that these bills now be read a second time. I call the member for Balmain.
Thank you very much, Mr Temporary Speaker. I rise this afternoon to speak on the Evidence Amendment, Evidence of Silence Bill and the Cognate Bill, Criminal Procedure Amendment Mandatory Pre-Trial Defence Disclosure. Mr Temporary Speaker, I don't think you'll be surprised to hear that I and the Greens are very concerned about this bill. I have seen very little evidence supporting the reasons why these pieces of legislation, proposed legislation, should be supported. And in my discussion today, I'll be drawing on information that's been provided to me by a range of different sources and also from information provided from the Bar Association. And if I may, Mr Temporary Speaker, I'd like to, first of all, address the evidence of silence matter. Now, as you know, the criminal justice system is based on a handful of fundamental principles: the right to trial by jury, the Crown to prove beyond a reasonable doubt, the right to legal representation. These types of principles are important, and of course the right to silence is important. And what we've basically heard from the government is, well, you know, we want a few bikies to say a few things, so we're going to trash one of the most important principles that's been around for over 300 years because we think there's, you know, a bikie issue we're trying to run on at the moment, and we suspect it should be something that we might be able to get some mileage out of. I don't know if the Attorney-General has been pressured by the Minister for Police, because I agree with the member for Heffron that the Attorney-General was welcomed as a breath of fresh air. And I quite frankly don't understand why this process is being carried forward, because the right to silence, the presumption of innocence and others, they're cornerstones to the criminal justice system. And I've spent some time listening to the speeches and looking at the history, and of course for over 300 years it's been protected by those accused of crimes by providing that no person is bound to give answers to questions that may incriminate them. It's a very important, critical, fundamental basis for our democratic system and of course our legal system. And any system which forces individuals to answer questions from police can result in the intimidation of innocent people when it comes to false confessions, particularly people from vulnerable groups, and we've heard members address that. And I don't know where the liberalism has gone from the Liberal Party. Because, well, the liberalism isn't reflected in these bills, because the power of the state and the protection of individuals when it comes to protection of silence is being systematically dismantled. It's being dismantled by this, because the government is claiming that we should trash those principles. Well, the Attorney-General says, what about people who get their houses shut up? We believe that's an incredibly important issue, but we need to protect fundamental principles. Next, the government will say, well, we destroyed the right of silence. What about trial by jury? We can get rid of that. What about a whole range of other things, right to representation? We don't need that. And this obviously is a concern that many people have, and that's why this is opposed so strongly by many. And I notice, of course, in the United States, it's protected by the Fifth Amendment, the right to silence. Where in this country, because the government's having pressure on the matter of people's houses getting shot, they're promoting this proposal, which in fact is ineffective. Mr Temporary Speaker, it is in fact ineffective. It's ineffective because it's been demonstrated in the United Kingdom and in other places that it simply does not work. And we've seen that in several instances that abolishing this right to silence is not effective. And we've seen the legal experts tell us thus. And we notice the government represents this proposal was also represented and discussed by the New South Wales Law Reform Commission in its 2000 report. There's no need for the curtailment of the right to silence. There's no evidence that the proposed amendments will affect the rate at which defendants plead guilty or are convicted. If the Attorney-General's got evidence, give us the evidence. Show us the direct, tested, reviewed evidence that says that will be the case. The fact is that there isn't any. And we also know the experience of the English legal system is the proposal will lead to, quote, a notorious minefield. Regina versus Beckles 2005, and that is clear that in the United Kingdom it is a minefield. And it has been found to be thus. But the government needs to try to come up with something in order to try to pretend that this will get increased convictions, this will in some way ensure that there will be an increased amount of pleading guilty, and there's no evidence to support that. If there was clear, tested, demonstrable evidence, we'd like to see that, and if the Attorney has that, well, I welcome that. The government's also used the example of evidence of an alibi, which was not disclosed at the time of the police interview but later relayed on a trial. In fact, defendants have no right to call an alibi evidence unless they have given notice in writing no later than 42 days before the matter is listed for trial. Section 150 Criminal Procedure Act 1986. This is information provided, as I mentioned at the outset, from the Bar Association, and I wonder how the government seeks to respond to that. So this notice must include the name and address of any proposed alibi witness if known to the accused. And furthermore, research conducted in Australia and overseas indicates that suspects rarely remain silent, and that's another issue, they rarely do remain silent. And so this question about modifying the right to silence is unlikely to increase prosecutions. And I did mention the impact on the Criminal Justice and Public Order Act 1994 UK, and this Section 34 that permits an adverse inference to be drawn where a defendant fails to mention issues later relied upon. Well, we know that that has led to significant problems, significant concerns, a notorious minefield, and surely that isn't a satisfactory way for us to proceed. And I just wanted to also conclude by saying, of course, that the issue about the lawyer being present is a significant one. Because there's a question that is it negligent for a solicitor to be present? Why wouldn't the solicitor say to their client, you know what, if I'm here and you're given this and you're given advice about this proposed legislation, then a negative inference may be drawn. So the solicitor will say to the client, say nothing, don't say anything, I'm leaving. And the solicitor will no longer participate in any discussion. And on that basis, this negative inference can't proceed. So why wouldn't you do that as a solicitor? Would it be negligent for you to sit there knowing that your client may well be advised of the requirement that is a special caution being given in the presence of a legal practitioner who is acting for the defendant? I'd be surprised if in fact solicitors didn't speak to their clients very quickly and say nothing and leave. And so even if this was effective, we know that it may not even be practical to be implemented because solicitors may well advise their clients to be quiet and quite frankly not even be in their presence so that a special caution could not be issued. And if these bikies are so clever at the moment and the government can't find and the police can't find them, surely that would be the approach that the solicitors would take. Simply don't be present, then a warning, a caution can't be given, end of problem, no negative influence can be taken. Just very quickly, Mr Assistant Speaker. Mr Assistant Speaker, I respect you, I want to make sure I get your title right. Mr Assistant Speaker, just very briefly onto the mandatory pre-trial disclosure. I mean, this is another catastrophe waiting to happen, isn't it? This is another disaster. We've seen in UK trials, trials within trials, where prosecution questions defence solicitors about, well, what happened? When did it happen? What did you say? What did he say? What did she say? And that's why the stakeholders in the Trial Efficiency Working Group canned this idea and thought it was a foolish idea and didn't believe it should proceed. That's my understanding. I mean, and that group has representatives from the DPP, the Bar Association, the Chief Justice of the District Court. I mean, the District Court deals with a very, very significant amount of indictable criminal matters, and you think if they were screaming for this, that they would come forward asking for it, but my understanding is that's not the case. The concern there, of course, is again there's no justification for the reversal in direction, which is where we're now required mandatory prosecution and defence disclosure, and fail to meet that disclosure may again result in an unfavourable inference. The concern again from the Bar Association and others, it will have a disproportionate impact on vulnerable and accused, particularly those represented by organisations with limited resources. The real question here is quite obvious. If the government is proceeding with this, will they be adding increased resources to organisations like the Legal Aid Commission and the Aboriginal Legal Service? Is that a fact? If that's not the fact, does that mean the government is guaranteeing that there will be no increased complexity, no increased cost for these organisations, which then means that there is no requirement for additional funding? That's something I'd like to see the Minister address, because it seems that there may well be even as we've heard from the legal fraternity, a proliferation of appeals to the Court of Criminal Appeal, possibly to the High Court, to clarify the appropriate content of the directions that may well be given. And we know that in the United Kingdom, again, where the length of trials increased as a result of evidence being included to explain alleged deficiencies in case statements and legal arguments concerning the need for proper judicial directions on the issue. Additional disclosure requirements, I understand, have been introduced in the UK. It's very concerning that the view of those who are engaged in the legal fraternity have identified this as a significant problem, and if it is something that will introduce increased complexity, which by all accounts will be the case, then the government must ensure that there is increased support for those organisations that protect the vulnerable and provide representation to them in the legal community. So, Mr Assistant Speaker, it seems to me, and it seems on the balance of evidence, that these bills are unnecessary, overly complex, and attack fundamental rights that we all hold dear. Thank you.
The question is, this bill